Hi everyone, this week's video is discussing social media and from the niche perspective of business accounts that are set up and used for work-related purposes. The most common networking tool for business is LinkedIn. The question is whether or not an employer can claim ownership of an employee's LinkedIn account once they leave the business. One example of where this may be really useful to an employee and to a business is somebody who is in a resourcing or recruiting role. They may have access to thousands of candidates through their connections that they've built up over LinkedIn. Alternatively, a salesperson may be connected to a number of business contacts that they may want to keep with them once they've left employment. The problem with most social media accounts of this nature is that they're typically owned and operated by employees, even if they've been working on the employer's behalf. They tend to be set up by individuals, and the terms and conditions of those accounts tend to suggest that the ownership is for the user and not for any other entity. LinkedIn has a user agreement which states specifically that. The employee will therefore allege, if they leave the business, that they retain ownership of that account, and that argument in the context of previous case law is likely to succeed unless there is an express agreement between the parties that shows the account belongs to the employer. And we have a case not involving social media, but Penwell Publishing and Ornstein, which related to the ownership of a journalist's contact book. He built that up on the employer's computer system. The High Court suggested that that address book, which was stored in Microsoft Outlook, belonged to the employer, even though it included both personal and business contacts, many of which the journalist already had when he joined the company. If he kept two separate lists, so one with contacts from prior to joining that employer, and one for those that he'd gathered as part of his employment, he would have been able to use the first list. So an employee can increase the chances of retaining ownership of a contact list by separating out purely personal contacts, or those built up prior to employment, from those which are stored on the employer's computer system. Now, employers are becoming more and more aware of the value in commercial information that's available on social media accounts. An example of where this has been used is in Whittaker publications and Gammage. An employee attempted to rely on LinkedIn's terms of use, so confirming that the user is the owner of the account, to argue that LinkedIn groups that she managed during her employment were personal to her. The employer applied for an injunction, essentially preventing it from using that information and delivering up the account back to the organisation. The court found that the employee's duties included responsibility for dealing with those accounts, operated purely for the benefit of the employer, using its IT equipment and to promote its business. It made an order handing over management and control of those groups to Whittaker, and this is irrespective of the LinkedIn user agreement, which states that that account is owned and operated by the user themselves. So the decision suggests that social media accounts used by employees for business purposes can be regarded as the employer's property. Crucially, however, this will only be possible where the employer places clear restraints on employees' usage of LinkedIn. So we may have an appropriately drafted social media policy, or we may have a provision within the contract of employment which expressly states that any social media accounts which are being used on behalf of the employer remain the employer's property and must be returned to the employer through the provision of passwords, transferring that ownership back once employment terminates. One other interesting issue relating to the transfer of information relates to social media accounts which are purely personal, so kept entirely outside of the individual's employment, where somebody has used that account as a repository for business information. So in Hayes Specialist Recruitment and Ions, Mr. Irons, a recruitment consultant, was bound by an express confidentiality provision and a non-dealing restrictive covenant. So this prevented him from dealing with any customers or clients for a certain period of time after he left. Mr. Irons set up his own company, which was intended to compete with Hayes. And before he left, he conducted a number of searches on Hayes' database of clients, prospective clients, and other candidates. He then contacted a number of clients on LinkedIn using his personal account, nothing to do with the company, inviting them to connect with him. Now, it was essentially judged that using a personal account as a repository for information which is highly confidential to the business is not permitted. He was in breach of his obligations, and he was not permitted to use the information. It had to be delivered up back to the organisation, and he was forced to disclose all emails and communications sent to his LinkedIn account from Hayes IT Systems, and evidence of all the business accounts that he had contacted using the information that he shouldn't have done. So in essence, there is significant risk around the proprietary information which is created by an employee through social media applications, and this will largely depend on the role that they perform. If that information is so valuable to the business, at the outset of the relationship, we should be putting in place some contractual provisions which clearly govern the ownership of that information and require the transfer back of any passwords and account information back to the employer once employment terminates. Very tricky area. If you do need further advice on this or preparing such contractual clauses and policies, do let us know. Please visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.